On Friday, the Supreme Court agreed to hear arguments in Missouri versus Biden during this upcoming term. This is the free speech case brought by attorneys general in Missouri and Louisiana against the federal government's coordinated effort with big tech to illegally censor and manipulate the free speech of Americans. The High Court also removed an injunction that limited the Biden administration's content moderation talks with tech companies until this lawsuit is decided, demonstrating why this case moving forward to the nation's highest court is so important. Joining us to discuss this is Missouri Attorney General Andrew Bailey. General Bailey, welcome back to Washington Watch.
Thank you so much for having me on and for covering this important story.
I think it's a huge story, and it's one that's not getting a lot of attention. But I would assume that the word from the court on Friday was kind of a mixed bag. Good news that this is going before the High Court, but removing that injunction is problematic, I would think.
Yeah, and as you pointed out, this is all about protecting our fundamental right to free speech in America. Disappointed that the court didn't allow the injunction to remain in place, confident that eventually it will allow that injunction to go into place. You know, we suffered the same setback at the Fifth Circuit Court of Appeals, and we've won twice there. We've won once at the District Court, twice at the Fifth Circuit Court of Appeals. The score is Missouri 3, Biden 0 in the fight for free speech. We're confident that ultimately the court will restore that injunction after hearing a briefing and oral argument on this matter.
Well, you and I have discussed this quite extensively on this program. You have a ton of evidence to make your case. In fact, so much so that the lower court, put that injunction in place, basically telling the Biden administration that they could not collude with social media pending the outcome of this case. So let's talk a little bit about the timeline. When will the court hear arguments in this case?
Well, we are hopeful that we can get the matter briefed and argued maybe before the end of the year, certainly early into next year. It's important that the court move as expeditiously as possible. We've got to build a wall of separation between tech and state to protect our First Amendment right to free speech, especially as we move into an election cycle. COVID was the excuse that Biden and his crony bureaucrats used, exploiting a national emergency to violate our constitutional rights and suppress any speech they disagreed with. We can't let them do that as we move into an election cycle. They've already proven themselves committed to future violations, and that's why we've got to continue to push and resolve this matter as expeditiously as possible.
So has the court put this on a fast track?
We're still waiting on a briefing schedule, but I'll tell you, we're going to use all available haste to make sure that the matter is briefed and argued. Certainly, we've done preliminary discovery. We went to court at the district court level back in May and put on a quantum of evidence sufficient to justify a nationwide preliminary injunction. Again, preliminary discovery for a preliminary injunction. We haven't even gotten to the merits of this case yet. We've got to continue to root out this vast censorship enterprise. But I'll tell you, the three judges that dissented, Justice Clarence Thomas, Alito, and Gorsuch, opined that there was sufficient evidence that was presented at the district court level to justify the stay. So we know we've already got at least three justices who are keyed in on this issue and ready to go. And so we've just got to get it briefed and argued. These are the worst First Amendment violations in this nation's history, when we've got to keep fighting, especially as we move into next year's election cycle.
Yeah, and as you mentioned, the dissenting judges in the court's opinion to remove or to stay the injunction, Alito wrote in his dissenting opinion, "This is most unfortunate," because he preferred to have that wall of separation where there could not be collusion between the government and social media to silence the voices of Americans. So let's step back for just a minute, General Bailey. You know, we may have some listeners that have not been a party to our previous conversations. Let's talk a little bit about the evidence that you've uncovered to date that shows this collusion and how the Biden administration coerced social media giants to censor the voice of Americans.
Yeah, that's absolutely true. And we've only, like I said, just begun to scratch the surface. 20,000 pages of documents or more, numerous depositions, all of that preliminary discovery to obtain a preliminary injunction. We can show you the emails where the White House Communications Office was directly censoring disfavored speech, calling to suppress a Tucker Carlson video, a Tommy Lahren post, to de-emphasize, deplatform, shadow ban anyone who questioned whether mask mandates or vaccines worked. And we put that evidence on back on May 26th at the district court level. And by the 4th of July, the district court ruled there were 82 pages pages of factual findings. That's individually numbered paragraphs that accumulate over 82 pages of facts that we put on based on evidence in court that the court believed and were dispositive of the court's ruling. So this isn't just the Attorney General in Louisiana and Missouri speculating that there might have been a violation of our constitutional rights here. We've proven it in court at this point. It's been affirmed at the Fifth Circuit Court of Appeals twice now. And I would point out too, like you said, it's coercion and collusion, but look at the district court's injunction that was affirmed by the Fifth Circuit that now is being reviewed at the U.S. Supreme Court. All it says is that the federal government can't coerce or control big tech social media. And what we know in the past is that big tech changed their terms of service agreements and their censorship algorithms to satisfy federal officials' demands. That has to stop. When we talk about the wall of separation between tech and state, that's exactly where the rubber hits the road.
When you get a court like the Fifth Circuit that puts in place an injunction from the Biden administration from colluding with social media prior to the actual case being litigated, that suggests there's strong evidence that you would prevail in the court.
Absolutely. One of the factors in the court's determination as to whether or not to grant a preliminary injunction is whether or not the party is likely to succeed on the merits, that the party moving for the preliminary injunction. And so again, that quantum of evidence that we put on, those documents, the testimony, the depositions, all of that accumulated over 82 pages of individual factual findings, that was sufficient evidence to show there's likely violations of the First Amendment here that the big tech was censoring at the demand of the federal government. And that's what we've got to put a stop to.
When you look at the evidence that you've gathered so far, are you going to have the opportunity as this case moves further to gather even more evidence?
Absolutely. Again, we've only begun to scratch the surface. We know for a fact that the vast censorship enterprise grew so quickly under Biden's watch that the federal government had to design a new bureaucratic apparatus to manage the censorship. That was housed in the Cyber Security and Infrastructure Security Agency within the Department of Homeland Security, CISA. CISA's entire purpose is to protect roads, bridges, and computer databases. And yet the director of CISA said, well, there's also cognitive infrastructure. So the director is committed to controlling what we say, what we think, what we hear, and that justifies in their minds their constitutional violations. But we're not going to let Joe Biden destroy free speech in America. We will continue to root out the vast censorship enterprise in merits discovery, and we will hold wrongdoers accountable if they violate the court order.
And General, I know you're not going to use hyperbole when you talk about this, and I've talked to your colleague in this and friend of mine, Jeff Landry. You've described this as a vast enterprise, and so this is quite extensive. Is this still happening? Is it still happening?
It absolutely is still happening. And that's one of the things the Fifth Circuit Court of Appeals latched onto. Not only are there people who won't come back to big tech social media platforms because they were censored, but it's not just the speakers, but the listeners whose rights were violated. Essentially, every user on big tech, their rights have been violated because they were deprived of information necessary upon which to make good personal healthcare decisions or potentially decisions at the ballot box when big tech suppressed at the federal government's demand the Hunter Biden laptop story. At some point, that becomes election interference. But I would point out, too, that the harm is still occurring because of self-censorship.
Right.
Again, people are less likely to want to talk about President Trump or COVID issues or election integrity because they're afraid they'll get booted off the platforms.
You're absolutely right. And there's a distrust not only for the government, but these platforms. I still question whether or not they're still doing the shadow banning and they're throttling back the traffic that goes to some sites. General, we're up against the clock, out of time, but you mentioned repeatedly this is going to affect the next election. Agree with you 100%. When would you expect a decision from the court?
Well, again, we're going to push as hard as we can to get the court to render a decision and make permanent that preliminary injunction. We are hopeful that would be handed down before next summer.
I hope you're absolutely right. General Bailey, always great to see you. Thank you for fighting the good fight. We appreciate it.
Thank you, sir. Appreciate you.